Okay, my name is Amy Dougherty, and I'm an attorney with Bluegrass ElderLaw. I'm delighted to join you today and talk about guardianships and some of the protections that are in place when there's a guardianship proceeding that's going on, and also alternatives to guardianship, which are usually much less intrusive. So if you can arrange for those for your beloved ones and for yourself, that would be better. I did want to say on my screen, there's something that says in the middle of it that it's being recorded. I don't know if you need to press the got it button or something like that. So let's talk about what a guardianship is. For me personally, it's one of a number of types of services, legal services, that I provide for my clients. And I help with estate planning. I help with estate settlement when somebody's passed away, and I help with Medicaid asset preservation, planning and applications, and a different group of services. But it's also something that I'm able to provide a lot of care for older folks, which is near and dear to my heart. And I'm glad that I get to be in this area. So what is a guardianship? Well, first off, it is a court proceeding. And that's important to know. It's not something that you can set up any way other than to file a petition in a court that has jurisdiction. You can advance to the next slide. And that in Kentucky, that is the district court. So you would go to the district court of in the location where the person that you believe needs the guardianship is living. And the court is the one that determines whether a person is disabled or not. So what we want to do is limit the guardianships to as few as possible if we can get an alternative set up instead. But they're for people that are unable to care for themselves, making their own healthcare decisions or their own financial decisions. The nomenclature in the area of guardianship is very important. A guardianship is for the personal affairs and healthcare decision-making for a person, and a conservatorship relates to a person's finances and legal affairs. So the terms, next, the terms are that, as I mentioned, the guardian deals with the personal affairs, and the conservator deals with financial and legal affairs. Sometimes a court will appoint the same person to handle both of these. That's very common. Now, other terms that you need to understand is the word respondent. This is actually a court case. So the person that files for the guardian is the petitioner, and the respondent is the one that's alleged to need a guardianship. And if a guardianship is established by the court, then that person becomes a ward or a vulnerable person. Different states use different terms. I like Arizona's, for example, which is a protected person. That's a much, I think, more appropriate term than a ward. There also will be a guardian ad litem, or GAL, who's a court-appointed attorney for the ward, charged with looking out for that person's best interests. You can go to the next slide. So lately, guardianships have come to the public's forefront through a movie called I Care a Lot. And I know a number of you have seen it, and some of you plan to see it soon. It is really a worst case scenario movie. Can it happen here? Some aspects of it certainly could. We're going to go over in detail some protections that should help this to not happen to you or your loved ones. There are a number of protections that we will go into. So just for those of you that haven't seen the movie, just quickly, it's about a person who's a professional guardian, and she's been able to make inroads with other professionals. A doctor lets her know when she's got clients that don't have family members that love them and want to take care of them or able to, and they're all alone and they have some wealth. And she gets the doctor to say, well, I'm really worried about her, and say that to court. And then she goes and gets an emergency guardianship and starts the whole process, whether the person needs it or not. And the movie's very good about portraying that these people didn't really need that kind of help, but they're forced into it through her really exaggerated efforts, including bringing the police with her to carry them off to a facility she signed them into. Okay, next. The second piece of public awareness of guardianships and conservatorships comes from Britney Spears. You might have seen the hashtag Free Britney. It's definitely the most famous conservatorship of all time. She's been under conservatorship of her person and her estate, both, so a guardianship and a conservatorship, since 2008. The court then appointed her father to take care of her. And interestingly, since 2008, her father has made a boatload of money off of her efforts. So this was one of the really negative pieces of this. By now, her dad has agreed to step down, and I believe the court will find that she no longer needs the conservatorship or guardianship. Interestingly, in 2008, I think she was having a lot of severe addiction issues that were untreated and was not acting appropriately and probably did need some help. But you can see one of the issues here is that once this process is set up, it's very difficult to conclude it and to get free of it, though there is a process. Next. What is the purpose of guardianship? I always like to point this out that we live in a free country. Every adult who is 18 years and over until your death is legally able to direct their own affairs. And nobody else can step in and do that for them unless a court says so, or unless they voluntarily make arrangements, which we're going to be talking about shortly. So I think to keep a free society, we want that to happen. Sometimes it's very difficult on people. They feel like I get calls a lot saying, my mom really needs help and she won't let me help her. She won't make any arrangement for herself. And I don't want to file for guardianship. I understand that, and the question is, what else can I do? Well, if your mom's unwilling, you can't do anything else but file for guardianship, because people are free and until they're determined to be disabled by a court of competent jurisdiction, which in our area is the district court. The guardianship's purpose is to be used only when necessary to promote a disabled person's well-being and protect them from neglect, exploitation, and abuse. Sometimes it's self-neglect and sometimes it's from others. You can go ahead and turn. Okay, and one thing that's very interesting to note, in Kentucky, there is no regulation of professional guardians. There aren't a lot of them. They are guardians that I consider would be professional when they are not related to the person that is the ward or the protected person. The court appoints them because there's no one else. There's just not a lot of regulation. There is a state guardianship program, which of course is a state agency, and so that's regulated, but the non-state professional guardians aren't specifically regulated in Kentucky. I just wanted to be sure that you all were aware of that. Okay, the next slide. So let's talk about what the disability standard is. It's all regulated by a statute, KRS Chapter 387, and disabled means it's a legal disability. This isn't related to, it doesn't track exactly about a medical disability. So a doctor's statement alone isn't enough to have you determined to be disabled in court, for example, but it's based on functional abilities. So if a person is unable to make informed decisions with respect to their personal affairs, they lack the capacity to provide for their own physical health and safety. and that includes healthcare, food, shelter, clothing, and personal hygiene. So it's a lack of capacity and it's a legal determination. Next. The person also can be unable to make informed decision about their financial resources. So they lack capacity to manage their property effectively, and to administer or dispose of both their real and personal property. And there's some safeguards here in the statute. This inability has to be evidenced by something that occurred recently, like in the last 6 months. So you can't file for disability claiming someone's disabled on material that's older than 6 months because you want it to be a real-time event. And it also can't be evidenced just by isolated incidents of these neglect, improvidence, or other behavior. Okay, next. So now let's talk about the protections and what the process is. So these are protections against a process gone awry, and we're very much hoping that they would be adequate. First off, as soon as a petition is filed by a would-be guardian, so that's the petitioner or the guardian, that person files a petition with the district court saying, for example, my mom is, in my opinion, disabled, and here's what my basis of opinion is. She has these diagnoses, and she can't manage her finances, and she can't, she's living alone at home and not able to do that, and it's a big risk to her health-wise. So you make that kind of allegation in the petition, and you also say, I would be a good guardian because I'm college educated. I handle my own finances. I have been handling moms for the last 3 years, for example. That kind of thing would be adequate to be named a guardian. Now, a professional guardian would need more information in theirs, but so the petition's filed, and then the court appoints this guardian ad litem right away, and that person meets with the would-be ward and talks to them about the guardianship process and figures out what they want or don't want and makes some independent assessment about the best interests and reports that to the court. There also are 3 interdisciplinary reports that have to be done. When you file a petition for guardianship over someone, you name 3 people that you would like to, for your mom in our example, or whoever the putative ward is, to see. So one has to be a medical doctor, one is a psychologist or psychiatrist, and the third one is a social worker. And these people file independent reports under court order, sending their reports back to the court. And I also wanted to be sure that I told you that these guardianship proceedings are confidential. So they're sealed records at the court. And so that keeps down kind of the public display of information about this. If these 3 reports are all on the same page, they all say, mom definitely needs to have a guardian because she won't let anybody help her and she's vulnerable and making bad choices that are going to lead to her safety and maybe demise. So if that happens, then usually the judge would just call the social worker at the hearing to come and make a statement on behalf of all 3 of the professional people. I should say too that the social workers often are people that are working for adult protective services, and they're very used to doing this kind of review, and so they do a good job and they present things in court well. And if all of those reports agree, then the judge would likely find that the person needs a guardianship and sign the disability papers. And then the second part of the proceeding is who's going to be named the guardian. And in our circumstance, we're a daughter who has a good relationship with mom and has been helping her anyway and filed the petition, would likely be named the guardian. Another process that's a protection from anything going awry is continuous reporting to the court. When somebody becomes a ward, they lose their civil liberties. And the person that is managing their affairs has to report to the court as a protection. You can't manage your own finances anymore. You can't decide where you're going to live anymore. Generally, you can't drive anymore. Sometimes you can vote, but it has to be addressed by the court as to whether you should or shouldn't be voting, and that box would be checked or not checked on your disability order. And so every year then the Guardian files an annual report saying how they use the money of the wards on behalf of the ward. There is a wonderful system in Kentucky that is unique in the whole country, and that is a possibility of a jury trial to determine disability. It used to be until the last legislative session that all guardianships in Kentucky were jury-based. The decision about whether somebody is disabled is a person who, the decision was up to the jury. And they would hear the evidence from the social worker and go and meet like a jury meets and then come back with their answer. The last legislative session made that an option, but not required. So often if the GAL who's met with the would-be ward and the 3 reports all come back saying this person really needs a guardianship, then they'll decide not to use the jury now and let the judge make that determination. So if the reports are all over the place, like the doctor and the psychologist say, no, they don't need a guardianship, and the social worker says they do, then it's probably time to impanel the jury. But it's really up to the judge and the guardian ad litem and how they want to handle that. So the jury decides if they're disabled, unless everybody's kind of on the same page, then the judge decides the disability. But even if a jury has been involved, the judge is the one who decides who should be named the guardian. This is an important event because a lot of times the guardians are, who would be the guardian is kind of a contested matter. Daughter 1 wants to be the guardian, but then daughter 3 thinks she would be better and files a petition too, and the judge has to decide which of the 2 of them would be better. One other protection against this process is if somebody's found partially disabled. That's another outcome that could happen from this proceeding about whether somebody needs a guardianship or not. The partial disability determination requires then the judge to say, well, they're disabled as to this function or that function or the other function, and that gets listed in the disability order. But then things that aren't listed they're left to handle. So it could be partially disabled and can't handle their finances, for example. Okay, you can go to the next one. And before we talk more in depth about alternatives to guardianship, I wanted to talk a little bit about the movie, I Care a Lot. One of the instances, Marla is the professional guardian there, and she finds this woman that decides that she's a cherry, which is very easy to pick off and has a lot of money, and nobody's got her back, and so these people can all swoop in. So you've got the professional guardian who is contacted by the doctor. In the movie, he gets a kickback for having all the paperwork, and actually it's a female doctor there, and she gets some kind of kickback. And then the man who operates the facility gets a kickback also, and they make all the arrangements and go to court. And the judge, unfortunately, is portrayed as a bit hapless here. Whatever this guardian says, he's up for. And so we don't really see in this movie the role of the guardian ad litem, which would be true in Kentucky. Now, I wanted to tell you also, if somebody's in kind of an emergency situation, there is a way based on a doctor's statement to have an emergency guardianship established, and that can be done within a week. And it's important sometimes because, I've had a client that wanted to write a $100,000 check out of her retirement account to a person she didn't know. Well, that's a pretty serious financial emergency. And so you would want the family to be able to do something then if they're, looking out for her best interest. So, but anyway, under this emergency guardianship in Kentucky, you also at the same time have to file for a full guardianship. So the process with all the protections I've mentioned is also put into place right away. And one of the protections in Kentucky is that the court has to approve the sale of real estate. Well, in the movie, Marla and her sidekick, the day that they get this woman unfortunately locked into a facility against her desire and complaint, they steal her cell phone, they do all sorts of things. That day, they have professional movers in clearing out all of her belongings, picking off things that they know will go unnoticed and they can just drop into their own pocket, and repainting the house and putting it up for sale. That would not be happening in Kentucky, thank goodness. So that's another protection I wanted to mention. Now let's talk about here about alternatives. And I did want to mention, I'm going to take all of your questions at the end. So let me mention these alternatives and we'll be sure and address every question that you ask here. So guardianship is a court process. A power of attorney is a voluntary arrangement that has to be established by the principal, who is the person naming someone else to help handle their affairs. So the person who does the appointing is the principal, and that person has to have some kind of competency. I meet with my clients who want to make appointments of powers of attorney all the time. I meet with them and I find out if they have a good relationship with the person they're appointing, if they trust that person, and what kind of authority they want to give that person to handle. So the person that they're appointing is called an agent, and that person, the agent, acts on behalf of the principal, and they have the authority to do so in anything that is listed in the document. So the powers of attorney that I draft when there's a good trusted relationship, typically between a parent and a child, is 10 pages long. It's very robust. And I do that because the law requires that the agent have been granted the specific authority by the principal in order to be able to act on their behalf. So we've got these specific grants of authority. They are to handle real estate, personal affairs, medical decision-making if the person can't do their own. It's very important to have these set up because, in my opinion, having a good power of attorney with somebody that you trust and is handling your affairs well is the best protection against ever needing a guardianship proceeding. If you do not name a power of attorney, then if you become disabled, and 70% of us do prior to death, then you have nobody to act on your behalf until they go and get a court to agree that they can do so. So it's this power of attorney, this legal document signed off by the principal, appointing an agent. And when I've got a person that has numerous trusted people in their lives, I name people in sequence, daughter one, daughter two, daughter three, however they want to name, whoever they want to name, friends, nieces, nephews, anybody that you trust that will do the job well for you. And that's really an important alternative to the power of attorney. Okay, the next one is the curatorship. This is a little known process, but it's also a court process. It's voluntary. The person who's asking the court to name a curator for themselves is often very fragile or vulnerable, but competent. might name a family member if another family member is trying to interfere. This is a pretty common fact pattern for us, and we're starting to be able to use these curatorships. Hopefully, they will work. The one situation is that they're for financial matters only and don't address healthcare matters. So if you have a curatorship where you've appointed somebody to manage your financial affairs, you would also need a healthcare power of attorney so that they or someone else could manage your healthcare decision-making when you are not able to do so. Okay, we've got another alternative is a representative payee at the Social Security office. Many times older folks have as their primary source of retirement their Social Security retirement funds. And if they can't manage those, you could ask the Social Security office for the paperwork that you'd need to take to that person, have them sign and say, yes, I want my son to be my representative payee. And as long as the Social Security Administration approves that and all the paperwork's filled out, then Social Security would send the check to son for mom. And he has to open up a separate bank account. It's the rep payee account, and it's noted on there that it's mom's funds, but he's managing them. And then a safeguard for that is every year the rep payee has to file paperwork with Social Security verifying, like through bank accounts and so on, how all that money was spent. This only applies to Social Security funds, so it may not be the full picture, but it's certainly one arrow in the quiver of protecting older adults. Okay, the next one is supported decision making. I'm not sure if any of you all would be familiar with this process, but it's very useful and often for developmentally disabled or delayed persons. There isn't a specific law that details all the requirements for this, but in other states, it has to be in writing and it's also court reviewed. And so a person has a team that they seek advice from, but they don't lose their own ability to make their decisions. It's a wonderful arrow in our quiver when it works, and it has been used in Kentucky, and I'm hopeful that it will be used on a greater basis in the coming years in Kentucky. Okay, the last protection is trusts. A trust is an account that is managed by a trustee for the benefit of someone else. So the trustee has the legal authority to manage, direct, and spend the money, but can only spend it according to the trust. And it would be for the beneficiary who, under our discussion purposes, would be the person who is in need of protection. So if the family can set that up, or if a person can set up a trust for themselves, a revocable trust that would be, and name a third party to be the trustee, then they wouldn't have control over those monies as long as they had moved the monies to the a trust account. And that could be a protection too against a third party scammer, for example. I'm happy to answer your questions, and we can discuss other aspects of both of these cases or anything else that you would like to discuss. And if we don't have enough questions, I can tell you some war stories.
Oh, well, we love war stories. But there are some questions.
All right.
So let's go through those. You answered my one about the guardianship, because I had always heard that, Kentucky was one of the states that had the jury process. And so now that's new and changed a little bit, but we still have it. So that's good to know. And let's see, here's the next one. Let's see, you may have answered this before. I had to tune out for a moment. Can the guardian from out of state, such as in a circumstance where the parent had to be placed in an elder care facility, for example, can their guardian be living out of state?
Yes, they would need to have a service of process agent within this state. So sometimes we get contacted by people saying, hey, my mom lives in Kentucky, I live in Connecticut, I've filed for guardianship and been given that. Could your law office be our service agent? So we would get the papers and the court would have somebody to reach us, and our obligation would be to make sure we stay in touch with the guardian and that get the paperwork passed on. It is not the preferred method by the courts. They like in-state people that they would also have jurisdiction over. So, and when you file a petition for guardianship, you are submitting yourself to the jurisdiction of the court where you filed that. But it's not preferred, but definitely doable. And I'm sure courts would prefer that to having the person handled by the state guardianship office.
Thank you.
So you did talk about this a little bit, and I just want to make sure that the person who wrote this, everything's clear and we have it, but can you address the difference between power of attorney and having guardianship? Is guardianship needed when someone has power of attorney?
That's a yes and no answer. Our hope is that it would not be. So if a person has appointed a power of attorney and that power of attorney is acting for them, and there's no third party trying to question that, then you shouldn't need it. Or if the person that did the appointing, if mom appointed you to be her power of attorney a couple of years ago, one of the things about powers of attorney is they could be revoked anytime. Mom can take out a piece of paper and say, I revoke the power of attorney I granted to my daughter last July. And as long as she takes that around to whoever has the POA and notifies her daughter, the power of attorney is over. There's no way around that. And so if mom revokes it, in our example, or if there are other people that are contesting for managing of mom and instead of the POA, or if the POA says, hey, this is a lot more than I signed up for and mom's not competent to do another one, then there could be a POA and we could still have a guardianship. But the real hope is that that's not the case.
Guardianship will take care, or the power of attorney will take care.
If it's not been revoked, if the POA is acting appropriately and there's no competition for managing mom's affairs, then the guardian should never need to, the POA should never need to file for guardianship on mom.
Can I give an individual situation without giving out too much detail?
That's fine with me. If it's fine with Terry, yeah.
Oh, yeah, go for it.
Okay. So in this case, the parents did issue power of attorney. Part of the issue is the mother has dementia and there are a lot of behavioral issues there and no compliance with meds, and it's really just very sad. And so we've tried like assisted living and some other things. And of course, we were told that you have to have guardianship in order to, she can leave, in other words, any time she wants. And it's just hard. It's just, I don't even know where to go with it other than we're not sure what to do at this point. So,
well, and I always say that a power of attorney relationship is a coming along the side of relationship. You have, as the agent, the person named, you have the authority to do everything that's listed in your POA. Sometimes POAs are 2 pages long and don't have enough authority granted to be useful. That could be another problem. But sometimes they're full, robust, you'd have every authority, but the mom also has authority. She retains that authority for herself. Sure. She's not been found to be disabled by a court of competent jurisdiction, and she can still revoke POA. She can do whatever she wants to do. And so if she's not, quote unquote, compliant with the plan of the agent to take care of her, then that would be a circumstance where guardianship might be needed if she's not, if she's acting in a way that endangers herself or others.
Sure. Yeah, we were trying to avoid that, but thank you for the distinction. I appreciate that.
Sure. Mm-hmm. Yeah, so like I say, powers of attorney are coming along the side of the principal's not deprived of any of her own authorities, powers, legal abilities by the document. And a guardianship is a deprivation of the ward of all civil liberties unless some like voting are specifically retained. So it's very drastic, but could be needed in certain circumstances, obviously.
If you have more than one child who's willing to take on the role of guardianship, does the judge just appoint one, or can there be two who are, good sound people, for example?
Yes. In my opinion, it's easier if one is the guardian and the other is the standby, which would already have papers on file. And so if something happens to guardian one, they just notify the court and get a new order and they're the guardian. If you've got two people named at the same time, if they disagree about something, that's going to be a problem.
Sure.
If you're handling finances with like a national agency, they'll want both of you to sign and be there. And it really is a problem potentially. So that's the same with POAs. I can just tell you when the rubber meets the road, it's better to have one at a time. Although I have clients say, oh, I love all three of my children. They all do a great job. We have to appoint them all at one time. And, I tell them, if you're appointing three, you might as well not do a POA because no bank is going to accept that. You've got to do the POAs in such a way that a third party finds that agreeable, and you have to set up the guardianships to the court in such a way that it's functional. So yes, both parties that would want to be named guardians, co-guardians, would need to file petitions. So if you don't file a petition with the court, you're not going to be named a guardian, but both could file and ask to be joint. And a lot of courts will grant that. There are just some practical problems with it.
Okay, thank you so much.
Mm-hmm.
Okay, so we don't have any more questions per se in the chat box, but
well, I see one here. I'm sorry, I pulled it up. I see one here about if mom and dad both needed guardianship. There would definitely be individual processes. They would each have their own court case, and the findings would be based on them individually. Each of the three, both of them would have to go through the three reviews by the three professionals. They'd be appointed attorneys and have their own process. Okay.
Thank you.
Mm-hmm.
Emergency guardianship. You said, I just want to make sure I get this right in my mind, that it can just be a doctor's note, a note from a doctor.
But the statute says that the doctor has to, he'd have to, or she'd have to say, this is my client, my patient, and I've seen X, Y, and Z, or I've diagnosed them with X, Y, and Z. And in my professional opinion, they are vulnerable to harm themselves or others, or their finances are at risk unless there's an emergency guardianship in place. So there's statutory language. I provide that to my clients that come in to file when I'm the attorney for the petitioner. I give them that language to take to their doctor to get if the circumstance dictates.
Got it. Okay. And going back to payees, I remember at one time, a long time ago, the city had payees for folks who weren't able to handle their finances and had family not able or unwilling to handle finances. Does the city still have payees? I haven't heard about this for a while.
I actually do not know the answer to that question. I have not run into any of them. And I used to actually work for legal aid of the Bluegrass, and I think I might have run into it at that point. There are people that would take that job, on. And one of my war stories is that I'm actually the representative payee and POA for a cousin of mine that lives in Arkansas. So dealing with the circumstances from Kentucky to Arkansas and managing all of his finances have been interesting, because it was just kind of, and all of a sudden I got the call his sister had passed, and it was like, boom, you're it. And so I had to actually go to the Social Security office and argue with them about, when I say argue, the lady said, oh, we need to get somebody in his community to be the rep payee. And I said, he doesn't know anybody there. And I, this is my family member. I want to take care of him. And so finally, she sent the papers to him to sign, and he sent them back, and I got named. And then, so my cousin living in Arkansas has all of his Social Security money delivered to a bank in Kentucky. So you can work it out, but it's a little bit dicey. So if you need a particular arrangement, try to push for it.
Okay. Okay. Do you ever have contact with protective services, adult protective services? I mean, do you work with them for emergency guardianships or
yes,
whatever?
I mean, that on a whole different topic, occasionally we'll have a client that it's just pretty clear that they can't manage their affairs and don't have anybody else. And, as a lawyer, even I'm a required reporter if I think somebody's endangered. So I mean, this has happened once or twice in my career. It's not a big, occurrence, but I'll have we'll have the police do a wellness check, and then we'll call Adult Protective Services ourselves and just give enough information to get help to the client, not disclosing any of their other confidences.
Okay.
But we do, when we're filing guardianships and assisting people in their role as the petitioner, I almost always list Adult Protective Services as the social worker to do the investigation, because they have experience with the evaluation process and with the court paperwork process, and with going to court and testifying. So they're a good source.
They know what to do, right? Yeah,
Mhm.
they know the routine. Got it. So anyhow, I don't think I see any more questions in the chat box. So war stories. These are always interesting and things I mean, you can learn a lot. You can learn a lot.
Well, let me just say, because somebody did mention it in the chat box, if you call the number on this last slide, we can get you scheduled and in short order, and it'd be my great honor to help you and your parents with whatever you need in any of these issues. So feel free to call us, and we'll describe our process and get you started and well on your way. And we don't have a big lag to meet with somebody. I mean, I've got appointments next week, if you need that. So, okay, some more stories. I have a client in Western Kentucky. Obviously, I'm not going to give you any details, but my client was the daughter who was raised on a farm, left home, was living in New England, and realized that mom needs a lot of help. And that dad and brother, who are living in the community with mom, are not providing enough help, and she's just worried about her mom. And so we talked about all these options, and it decided to file for guardianship, and we filed emergency guardianship. I made a trip to Western Kentucky for the court proceeding, and interestingly, the judge, based on we didn't get that a doctor's statement, but my client put together an affidavit. So anyway, the judge believed my client and thought mom was endangered and issued an emergency order. And interestingly, he listed a number of things in the order that he was requiring, and including how much care a week had to be brought into the home, and protective devices such as a bed that for mom to sleep on that when she got up would sound an alarm, so because she fell and then nobody could hear her. And so a couple of nights she spent the night in pain, a lot of pain, grappling on the floor, which is just terrible. And so, my client was trying to come to mom's rescue, and we were able to do that. And then it's interesting because eventually when we had the full on hearing, the dad and son brought in mom. She was having a good day. And the jury, who was impaneled because of the disagreements and family issues, believed that the dad and son would take care of her and didn't need a guardianship. So that was, in my opinion, an unfortunate outcome because the daughters really had a lot more insight, and it was 3 of them that were involved in mom's care needs. But it illustrates that you can start down this process and do some good, and sometimes you can do all the good in the world, and that's exactly what was needed. But if there's a lot of family contention, sometimes it's not particularly that helpful. And then I was going to tell you about a case from a long time ago when I was a legal aid lawyer. I did elder law for legal aid of the Bluegrass. I had a client that was under guardianship because he was just had nobody and wasn't making good decisions. And I had done something and tried to help him with that, but then the guardianship was filed by Adult Protective Services, and he was placed in the state system because there was nobody else to step in and manage his affairs. And I don't know who the guardian, the state employee was, or any of the circumstances, but basically the only housing they could find him, moving from the hospital to housing when he was ready to be discharged, was a personal care home, which simply was not enough care. He shared a room with somebody, but it was on him to dress, shower, provide for his own well-being. He could sit down and have prepared meals, and he could walk up to a counter and be given his medicine. But that was the only support he got. And he needed full-on scale nursing home assistance. So that was kind of a difficult circumstance for me to see that even though you have these protections, sometimes the resources just are not there to provide for them. So one other concept I wanted to talk to you about was the idea of the least restrictive. Back to our great old American way, which I fully support, of every adult being able to call their own shots unless something happens, then you want to have the least restrictive safeguards put in place for a person. And so a power of attorney where somebody can just help you, but you can still help yourself is a very low restriction, and then even like somebody living wherever arrangements they're going to live in a personal care home where they have meals and medicine provided is the least restrictive versus full-on nursing home care or a lockdown unit if you've got dementia or mental health issues. So you want to, when you're looking at providing care, assessing care needs and providing care, you want to look at developing the least restrictive circumstance that's still going to provide adequate care for people. Do you want? Pardon?
That makes sense. I mean, but you want to make sure everybody's protected and cared for.
Yes, definitely. Are there any other questions that I could help you with?
Doesn't sound like anybody's coming through. You might get some private emails.
That's fine. Email away. I'd love to interact with you.
Right. Well, anyhow, thank you, Amy, then for sharing your time and your expertise with us today. Very much appreciated, because this really is a topic that is, we're kind of all at this age, all of us caregivers who, this is a message that things are starting to happen with our folks, and we need to have some ideas of what's going to happen.
Yes. Well, look at Britney Spears. It took her a number of years to get out from under her circumstances. So we really, you don't want to do this if it's not really needed. And also, if you become, if you become a ward, there is a process for getting out from under it. And I have been able to witness it in court several times, which makes me happy, where somebody had an injury that they actually healed from, for example. But it's a hard process if you look at some of the things, and I care a lot, and Britney Spears. It's we've got issues to grapple with in the coming years to provide protection and dignity for older folks and still safeguards. So.
Absolutely. Absolutely.
Yeah.
Those are good ending words. Wow. Something to think about. Thank you again, Amy. And thank you everybody for taking time out of your lunch. Have a good day. If you have any questions, give us a holler. Thanks.
Thank you.